Waqf Amendment Act 2025. Quite a good amount of curiosity has been generated by this Amendment Act. In general, public also is willing to know what is there and what is being opposed. When the Waqf Amendment bills were introduced in the Parliament, a number of petitions were filed in the Supreme Court. In those petitions, the main contention was raised that the amendments proposed in the bill were in violation of Article 14, 15, 25, 26, 29, 300A of the Constitution of India. Grounds of challenge. I went through the copy of the petitions or the material available on the live law, and by reading some of those petitions, certain grounds which came to the knowledge, I am hereby referring to them so that this becomes easily understandable for the common people, such as Act 25. It is important to say that the Waqf Amendment Bill has been passed, has received assent of the President. Now it has become Act. Now this Act provides state intervention in management of Waqf properties, whereas in Hindu and Sikh affairs there is no intervention of state. Although this objection is to be handled at this preliminary stage before proceeding to the further grounds of challenge. That means the Endowment Act, Hindus Religious Institutions Endowment Act 1997, may also be referred to, which puts the control as well as the income of the religious institutions of other, say, Hindu temples under control of the government. Another ground of challenge, the petitions which were filed before the Supreme Court are: now a person practicing Islam for at least 5 years can only create waqf. That means individuals recently converted to Islam cannot dedicate their property for waqf. Waqf by user omitted. That is, Waqf tribunal's power to recognize property as waqf based on historical usage is curtailed. Inclusion of two non-Muslims in Central Waqf Council and State Waqf Board termed as unwarranted and arbitrary, since no similar conditions have been put in other religious institutions. Now, district collector has to determine the nature of Waqf properties, not the Waqf Board. Other grounds are mandatory digitization, that is, filing of details of Waqf properties on central portal within 6 months. Now, government properties cannot be declared Waqf properties irrespective of historical evidence or user. Even Archaeological Survey of India protected monuments too cannot be declared. The properties of Muslim members of scheduled tribes cannot be declared, nor they can hold properties as Waqf. CEO of Waqf Board need not be a Muslim. Now, Waqf cannot be created orally by the written deed, but by the written deed only. Now, adjudicatory powers transferred from tribunal to executive authorities like the district collector, and the curtailment of tribunals' powers of stay from eviction is also there. A right of non-Muslims to create valid waqf had been taken away. In the originally in the Waqf Act 1995, it was conceived that the non-Muslims would not be creating waqf, but by amendment in 2013, this right was included. Now again, it has been curtailed by the new act. Thank you. These notes have been prepared on the basis of the grounds mentioned in the petitions as available on the live law. Thank you.